What we're going to do is we're going to, surprisingly enough, run through some slides of things that we think it's worth you being aware of as you currently employ or plan to employ members of staff in your parish. Confidentiality, anything that is said in this room will stay in this room, except of course we're being recorded. So how we're going to work with that, and we've talked about this in advance, is if we say something that isn't clear to you from the contents of the slide, please ask us a question for clarity. We will then repeat the question so that it definitely gets recorded. If you want to share something about your parish, even if you are really, really careful and keep anyone's name and make the situation anonymous, there is of course a chance that somebody who watches the recording might guess who it is. So what we'd like to do with that we want to talk to you about those sort of issues, but we want to talk to you about those sort of issues after the recording's finished. So if you can hold on to, I've got a situation where, until we finish the recording, that's probably the best way to go forward. So thank you for that.
You'll notice there are some pens and post-it notes. If you've got any questions, then please do write them on there, and we'll do a little bit of a Q&A after the session, and we'll send the answers out over the next coming weeks. So our session this morning covers employment contracts, pay and pre-employment checks. So the first one is pre-employment checks. So right to work checks are something that you should all be doing. They are typically a passport, a British passport, or there are alternatives. So we will send the slides out afterwards, but if you follow that link, it will give you more information if people don't have a passport. So it could be a government document, your birth certificate, anything with your national insurance number on. There needs to be 2 documents, so it could also be a letter from HMRC, Department for Work and Pensions as well. So it needs to clearly state the individual's name and their national insurance number. Should also be collecting 2 references for any successful candidates you employ. So they could be from current employer or a previous employer, and one could also be a character reference, so it could be another vicar or somebody else. They are to verify their employment performance and suitability for the role. And there's also safer recruitment and disclosure and barring services, so DBSs. It's for any role that involves regular contact with work with children or vulnerable adults, and you must be recruiting within line with the Church of England's safer recruitment and people management guidance. Again, there's a link there, so please do use that link, or please speak with our diocesan safeguarding team who are there to support you. And there's also medical checks. Again, these aren't a requirement, but it's good to have, because you can support your employees through their employment. Moving on, Geralyn.
Right, okay. What is the difference between an employment contract and buying a fridge? So, let me tell you. When you buy a fridge, it doesn't answer back. Well, if it does, you've bought the wrong sort of fridge. Your relationship with an inanimate object, it stays where it's put, it doesn't change. An employment relationship isn't like that. We have all had experience of working, I guess, in the past. And jobs morph, don't they? They change. It's not always clear. And so and when you say something to a fridge, not only does it not answer back, but it doesn't understand. When you say something to an individual, it may be that they understand it, but they don't understand it in the way that you expected them to. And so therefore, the contract is in some ways the same. There are 3 elements of a contract. And in lots of ways, a consumer contract is not that different from an employment contract, except when you're trying to work with it. So what we've got here is so first of all, does an employment contract need to be written? Well, technically, no. Technically, you can employ someone on a verbal contract, but of course, thinking back to they can answer back, they may not understand. It is much more difficult if you don't write it down. If you write something down, if someone doesn't understand it, they're more likely to ask you about it. It's not, well, you said X. Well, I meant Y, but you said X. Well, X doesn't mean that to me. That the way I've used the words is different to the way that you've heard them, and that's best avoided. So it is sensible to have an employment contract. In any case, under the Employment Rights Act, there is a requirement, a day one requirement, so the first day of employment, to provide an employee with a statement of the main terms of their employment. So you might as well issue a contract, and that's the sensible thing to do. And what we've done is we've put down here what needs to be in a contract for it to make sense. Most of this needs to be in the statement of terms anyway. And there's two types. We'll come on and talk about things that are implied in the contract at the minute. So at the moment we're talking about express terms, okay? So the things that should be written down. So it's always sensible to put the name of the employer down and the name of the employee, the job title, the start date of the employment. The start date of the employment may not be the same as the start date of somebody in that particular role. So, for example, if Georgina, who's worked for the diocese for 3 years, moved jobs into another role, it might be sensible to give her a new employment contract, but the start date of her employment, assuming there hadn't been a break, would be the date that she started with the diocese, because that's when that's when the clock starts to tick. So her employment rights relate to when she started with the diocese rather than when she started in a new role. So that's quite an important thing to kind of bear in mind. It's always useful to put down how much people are getting paid. They kind of like that, in my experience. And also normal working hours and days, and if they vary, how they might vary. So that's fairly straightforward. People want to know when they can go on holiday, and other things that are worth picking out of here. Pensions information. There is a requirement to explain about pensions, particularly because of pension auto-enrolment, which, as you'll probably know, is a legal requirement, unless somebody opts out. We'll talk about that a bit later, but it needs to be in the contract. And details of notice periods. I mean, some things I'm not going through because I think they're fairly straightforward, but notice periods are interesting, because the notice period for an employee is based on how long is agreed, and it's usually a week in probation and a month after. For an employer, there is a different set of rules, which are there's a requirement to give statutory notice. So for the first 4 years, up to the 5th year of employment, it's 4 weeks. And after that, once you get to year 5, if someone's completed 5 years employment, it's an extra week per year, up to 12 years. So you could have somebody who has worked for you for 12 years and is entitled to 12 weeks notice if the employer gives notice, but only needs to give 4 weeks notice if they choose to leave. So what if there's an error in the contract, or a term is ambiguous? Well, I kind of talked about that a bit at the beginning, in that if it's not written down, it's going to be harder to sort that out. If there's an error or an ambiguous term in a written contract, because the employer wrote the contract, an employment tribunal would, in most cases, unless it's so obvious that it's an error, so if it's an ambiguous term or something that that isn't, only becomes an issue once a dispute arises, in most sets of circumstances, an employment tribunal would decide in the favour of the employee because they did not write the contract. There's a term in all contracts called, or an example to use, of the officious bystander. That's probably me, okay? So an officious bystander stands there and goes, but don't you mean this and don't you mean that, to really be picky about the contracts. In some cases, it's so obvious what it means that even if the words are wrong, the way the contract's been working in practice means that that's what's been agreed. So it's worth bearing in mind, but the important thing is get it as clear as you can to start off with. Don't wait for your officious bystander to be difficult about it. Okay, can we move on to the next slide? Okay, so we talk about the express terms, the terms that are written down. Implied terms are terms that are implied into every employment contract. You don't write them down. They're implied by case law, a bit by statute, and we'll talk about that in a moment. But so there's a duty of care. An employer has to have a duty of care to their employees. That's not written down. You don't have to write that in the contract. It's there because it's an employment contract. By virtue of it being an employment contract, these duties are in there. Okay. So let's pick up some more that might be useful. Okay, the employee has a duty of faithful service. They should work in the interests of their employer. And faithful service sounds like an interesting term for that, but that's what that means, okay? An employee has to obey lawful and reasonable instructions. So if an employer asks somebody to do something and they don't wish to do that, if it's lawful and reasonable within the within the parameters of the role, then they are required to do that by this implied term. An employee is also required to look after an employer's property. So if somebody leaves a laptop lying around and it gets damaged, they've got, under their employment contract, there's an implied duty for them not to do something like that, to take reasonable care. And there's a duty to provide personal service. That's kind of relevant when we start to look at who's self-employed and who's an employee. So I'd ask you at the minute just to file that in your mind for one of the slides later on. So those are implied terms, generally by case law. The equality, the entire implied term of equality arises from the Equal Pay Act, mainly, of 1970. I don't know whether any of you saw the film Made in Dagenham, which is quite old now, but that's about women who argued for equal pay at Ford's, and that's how, in the 1960s, and that's how the Employment Rights Act it started to incorporate equal pay. So there is in every employment contract, it doesn't have to be written down, but there is an implied term that equal pay and equality will be in the employment relationship. Okay, right. So the next question that we thought might be helpful for you to is, well, you've got this relationship, but something's changed. What do we do? Employment relationships change, they vary, things happen, life moves on, jobs morph. So how do we know how to approach a variation in terms of the contract? So a contract can be varied by performance. So Georgina, my beautiful assistant, has been working at her job, and it didn't say in her job description that she would open the office up on a Thursday morning, but for the last 2 years, Georgina has been opening the office up on a Thursday morning. It's not in her contract that she comes in a bit early to do that, and one Thursday morning, Georgina doesn't come in, and the office isn't opened, and nobody can get in, and it's a major crisis. So, has that been incorporated by performance into her contract? As her boss, I say yes, it has been, because every Thursday, without fail, until this Thursday, madam, you have come in and you have opened the office and everyone has got into work. You say, but Geralyn, this isn't in my job description. And I say, but you've carried on doing it. You've never said you want to, you've object. It's a bit late in the day to object after 2 years of doing it. I would be arguing that it's been incorporated by performance. I mean, in all likelihood, you just turn up with a key next Thursday, because, it's not worth a big dispute about it. But it does show how things can change in an employment relationship. And so it would have been more sensible for me to say to her, you've been doing this for quite a long time. Should we write something just to say that this is what you do? And not to have left myself exposed to all of our colleagues not being happy on a Thursday morning because they've come into work and they can't get into the office. Varying by efficacy about how the contract is carried out. New changes in technology are a good example here. Something's happened, which means a job has changed because the processes are different. Varying by agreement, by far the best way to do it if you can. So a letter to say, your hours have changed on a Thursday, you're coming in at 6:30 in the morning to let everyone into the office, or however early it is, and then Georgina signs it, gives it back to me. We know where we stand. That is by far the best way of doing it. If there are lots of changes, it is worth reissuing the contract. For 6:30 on a Thursday morning, I wouldn't reissue a contract. But if there's a change of work location, a change of hours, change of pay, lots of other things that are happening at the same time, it's easier just to issue a new contract. You kind of know where you stand then. One of an example about that is if you have different notice periods for different levels of staff, and you do everything by a letter of variation, very often the notice periods get missed as a change that needs to be made. So issuing a new contract in some situations is sensible. Burying without agreement. Employers can and do vary contracts without agreement from employees. It isn't the best practice, it's not good practice, but it may be a situation where actually it's the only thing an employer can do. For instance, if they're facing massive financial problems and they need to change things quite quickly, there is a process that you can go through, but if there isn't agreement, it may be appropriate to try and change the contract unilaterally without the agreement of the employee. The risk there is you get to a situation which at the moment is legal but may not be when the new Employment Rights Bill becomes law, which is called fire and rehire, and that's been in the news quite a lot. So it is not illegal to dismiss somebody because they won't agree to new contract terms. It isn't without risk, though, because it's a potential risk of unfair dismissal. And what I would say, rather than go through lots of quite difficult employment sensitive legal issues and take too long and potentially bore you, is if you're in a situation where there isn't agreement but a change needs to happen, come to us for some advice. That's probably the thing to say, and hopefully that won't be the way things develop, but don't do that on your own kids, I think is what I'm saying. Okay. Also, some variations are so big that actually what you might be in a situation of doing is looking at a redundancy rather than a contract variation. So there's definitions of redundancy, for instance, include closing the workplace. Okay, so if you need to move from an office in Y to another part of the parish in Z, that's a potential redundancy situation. Obviously, if people agree to a variation by letter, it's not, okay? And it may be that actually what you're offering is suitable alternative employment, the same job somewhere else. But of course, if your member of staff can't get to, because they don't drive, say, or they can't do it within their childcare arrangements, they can't get to the new place of work, it's not suitable because they can't do it. It might be alternative employment, but it doesn't meet the suitability test. And in that situation, you could be looking at a redundancy because you can't agree a variation. Okay, right, would you like to?
So what makes an employee? So there's a mutuality of obligation, so the employee is required to work and the employer must offer work. So on the screen, so you're obliged to pay them, provide the equipment they need, so it could be a laptop, it could be a phone. They are under control of the employer, so there's usually an employee handbook, and they can't substitute, so send in somebody else there to do their job, because that's not what you were employed to do. And they must obviously give notice to end their employment, as must the employer to the individual, and there is obviously entitlement to redundancy pay if their service does exceed 2 years of employment. So that is what makes an employee.
Right, okay, so what makes a worker? There is no mutuality of obligation. So whilst with the employee, we're obliged to offer work and the person's obliged to do it, with a worker status, I'll do this and I'll explain 3 types of status in a moment. So the worker status, employment work does not have to be offered, nor does it have to be accepted. So in a parish, for instance, quite often I've had conversations with parishes about people who run the tech for services. And they're not always needed. It depends on the type of tech, it depends on the type of service. So they may very well have worker status and a worker agreement. But that does mean that they don't have to come and perform the task for you if they are not wanting to do so. You may not want them and they may not want you, but that doesn't necessarily work at the same time always. So if you've got workers, it's better to have more than one who's got those set of skills for you. Okay, there are some statutory payments that they are entitled to. So they're entitled to the national living wage, and we'll talk about pay in a little bit. They're also entitled to holiday pay. And that's always quite difficult, isn't it? Because if somebody works for you quite irregularly, working out what their holiday pay isn't easy. So the Working Time Directive says that every worker is entitled to 5.6 weeks of annual leave. And people often say 28 days. And whilst for a full-time worker, 5.6 weeks, and I'm sad enough to know this, is 28 days. However, of course, if you work very few hours, it's not 28 days, it's 5.6 weeks based on how many hours you work in a particular week. The easiest way to pay workers who work quite irregularly for their holiday pay is to add it to their hourly rate. And the percentage that you need to add is 12.07%, because 12.07% equals 5.6 weeks of the annual year. Yet again, I'm sad enough to know that. So that's quite important, okay. So for some people, they may be entitled to statutory sick pay, and that will depend on what they've earned over a period of time. If you're not clear about that, you can either look it up online or you can let us know and we'll help you work that out. Workers can acquire employment rights. Georgina has very helpfully talked about redundancy rights accruing after 2 years' employment. If you have a worker on a worker agreement who works for you very regularly, or where there are anticipated periods of work, and I'll talk about that in a moment, then they could, if they've worked for you for 2 years, they could have acquired employment rights. So if you have somebody who works for you, is at university and works for you every holiday in a cafe that you run as part of your church, part of your parish, then it may be the case that they acquire employment rights if they do that for 2 years or more, because they can anticipate that they'll work for you every holiday. Once they get to 2 years, the mutuality of the employment relationship means the likelihood is that they've got employment rights. It's fact sensitive. It's dependent on what the arrangements in a particular case are. And therefore I'm not going to give a definitive answer to that, but it's worth bearing that in mind. If you've got people who are coming to you regularly like that, then it may be that they do get employment rights. And there's a legal case about students and cafes, which I won't bore you with, but they did accrue employment rights, and when the cafe closed, they did get a redundancy payment. So if you don't do that, if the arrangement is truly around not having any mutuality or working patterns in that way, then they won't qualify for redundancy. So if you like, the default position is they don't qualify for redundancy. They can't take unfair dismissal claims, but situations, the facts of the situation and the context may mean that that's not quite right, and that's why we need to look at each case on its merits. Unlike self-employment contractors, they aren't carrying out work for a client or a customer on their own. We talked about the implied term of personal service in the employment contract. And that is the personal service where Georgina comes to work and carries out her role. If Georgina doesn't fancy it one day and sends Leanne, then because Georgina just doesn't fancy it, That's not acceptable. That's not an employment contract arrangement. The employment contract is that there's a personal service. The contract is between Georgina and the organisation. She cannot move that contract. She cannot subcontract to Leanne to come and open the office at 6:30 on a Thursday morning, for instance. So that isn't how that works, and it's not how it works for workers either. It is how it works for self-employed people, and we'll talk about that in a moment. So it is better to have a worker agreement. It may seem overkill if someone's doing the tech once a month on a Sunday. An employment contract is much more complex than a worker agreement. Excuse me. Standard worker agreements we can provide to you. It is sensible to have one. Otherwise, there is this ambiguity that can get built in. I thought you said this and I meant that. It's better to avoid that if you can.
Can I just ask a question? Does a worker have to be paid?
Yes.
So it's a paid person rather than a free volunteer person?
Yes, absolutely. Yeah. So there are three types. That's a good question. Thank you. There are three types of contract, if you like, miraculously on this slide. Brilliant. Okay, so there is an employment contract. Okay, full-time, part-time, really doesn't matter. Fixed term also can be an employment contract. 0-hour contracts are worker contracts because there's no mutuality. Okay, 0-hour contracts are contracts that get a really bad rep, and for a lot of companies, that's fair. Because for a lot of companies, it can be that they are using them to avoid people acquiring employment rights. But actually, they do have a place in life. Because if I'm using the person with tech for services, what sort of other employment contract could you offer? You don't want regular hours. They don't want regular hours. As long as it's agreed mutually, they have a function and they have a service. As things currently stand under the Employment Rights Bill, and of course that's subject to change as people around the government keep on changing roles, I don't know what's going to happen with this if I'm honest. And originally when we started to write this session, we were going to do a session on the Employment Rights Bill. I'm so glad it all started to change before we'd done much work on that, is all I can say really. But there is, as the bill is currently drafted, there is a requirement for employers to look at 0-hour work arrangements every quarter and to offer the worker the opportunity to move to an employment contract on the average hours over the last 12 weeks. So say Hannah had worked 5 hours a week for the last 12 weeks, I would be obliged as your employer to say to you, would you like a contract for 5 hours a week? And you, Hannah, could either say yes or no. That's entirely up to you. But under the bill as it's currently drafted, it is my responsibility to ask. The reason it's 12 weeks is because, yet again, under the Employment Rights Act, the 1996 Employment Rights Act and the Wages Act, a week's pay for people who work variable hours is calculated over 12 weeks, excluding any week for which they haven't been paid. And that's why the 12 weeks is the figure in there. Okay, right. Would you like to? Okay. Right, okay. So, of course, parishes will engage self-employed people to do the window cleaner. May very well work for themselves if you've got a window cleaner. If you can afford a window cleaner, you're unlikely to have them as either a worker or an employment contract, or you're going to do it yourself. But, you know, if you have somebody, that's how it's going to be. They generally look after their own tax and national insurance. Some contractors do something under IR 35, which is a tax arrangement, but we won't go there with this. They can substitute. So if Rachel is my window cleaner and can't make it 1 week and sends Georgina, that's fine, because all I want is my windows cleaned. I really don't mind who does it. So that can work like that. But you're cleaning windows on my church, I am responsible for elements of your health and safety. I have to provide an environment that's safe enough for you to work, although, as with everybody else, there's a responsibility for you to take care of your own health and safety too.
There's also employing family and young people, which you might do in your churches. So if you're employing family, wherever possible, please don't line manage them. Get somebody else to do that just because of the relationship. Obviously avoid special treatment, so pay, promotion, and working conditions. You still need to make sure that the tax and national insurance contributions are paid and have employers' liability insurance that covers all employees, and check the position of any young family members. You might employ young people. So you can employ young people if they're 13 and over, but there are special rules. Again, there is a link in the slide, so please do refer to that one, about how long they can work and what jobs they can or can't do. Once somebody turns 18, they're classed as an adult worker, so different rules will apply at that age. Please make sure you do risk assessments for all young people in your church, and they are entitled to have paid time off for studying and training, and they are also entitled to redundancy payments too.
Right, pay. Okay, so there's often confusion about what's the difference between the national living and the real living wage, and that's hardly surprising because there's only one word difference between both terms. National living wage is set by the government. It is the law, okay? It is based on, the increase is based on economic factors. The increase is usually announced in the budget, so we should be hearing what that increase is reasonably soon. It's age-based, it's different for people under 22 and over 22, and it's usually lower than the real living wage. In fact, it's always been lower than the real living wage. The real living wage is voluntary. You don't have to pay it. You have to pay the national. You don't have to pay the real. It's set by the Living Wage Foundation, who look at the cost of living. They have a basket of paid items that they look at the prices of those items. They look at the cost of living based on that. And there's a London rate and a non-London rate. So that's the difference. There's no age rates, but the rate is more dependent on where you're living rather than how old you are. And it is usually higher. In fact, it has always been higher. The real living wage, we don't know the figure yet. The expectation is it's going to be announced in Real Living Wage Week, which is in October. So we should know fairly soon what that is. As a diocese, we're signed up to the Real Living Wage, although I know for some parishes that isn't what is affordable and the national living wage is paid. Can't go below the national living wage, could go below the real living wage. Right, okay, so those are the rates as they stand at the moment for the national living wage, and as I say, they will potentially change, but that's how it is now. Okay, pensions. Pensions become an issue where somebody earns more than £10,000 a year. Now, if somebody's working quite a number of hours and you're paying the real living wage, it may be that they tip into the pension, the pension regulations. So in 2012, the government introduced pension auto-enrolment. Everybody who met the threshold, which was a bit lower in those days, to be fair, had to have the opportunity to enrol in the pension. And the assumption was that unless someone opted out, they were in. Okay. The idea was that it helped people to save for their retirement. In the beginning, the contributions were low. It was a percentage for the employee, percentage for the employer. The percentages are now a total of 8%, with the minimum being paid by the employer being 3%. So in most parishes, the employer is paying 3% and the employee is paying 8% to make the 5% to make the 8% up. There's no reason why that the employer is paying 3% except affordability. Employers could pay more if they're in a position to do so. If somebody starts work, the assumption is that they're auto-enrolled. There is a period of time, a month, in which they can opt out, and getting that right is really important. So if they haven't said they're going to opt out at the end of that month, then they're opted in and the payments need to be made as part of the payroll. Basically, it's done, so it's not done separately. And there's a re-enrolment every 3 years. So one of the difficulties I think that does happen, and certainly has happened where I've worked before, is somebody opts out of the pension scheme. 3 years later, there's an automatic re-enrolment, because you've got to do that every 3 years, and employers must re-enroll, and therefore someone's opted back in again, and unless they're really quick off the mark, they start to pay pension contributions when they didn't expect to. So when you get to the point of doing re-enrolment, make sure that employees know, generally, if they've opted out, they need to opt out again. It is unlawful, illegal, and against pension regulation for any employer to encourage people to opt out. So how you do that communication, how you communicate the option of opting out, is really quite important around wording, because you cannot be seen to encourage employees to opt out.
Lovely. And this is our final slide on statutory entitlements. So as employers, there are a whole host of statutory entitlements employees can receive. They are listed on the screen. So statutory sick pay, or SSP alternatively known as, maternity pay and leave, paternity pay and leave, adoption, shared parental leave, neonatal care pay and leave, which is new this year, and then statutory parental bereavement pay and leave. We don't have time to go through all of these today, but if you've got any questions on any of those, we are around this afternoon, so please do come grab us or drop us an email, which, if I move on to the next slide, our email address is up on the screen there.
Just very quickly on the statutory payments, if somebody is a worker and they're working regularly and earning quite a bit, they may still qualify for these. So it is a case of doing a bit of checking. And that's just a kind of government health warning, if you like, that don't assume if someone's a worker that they're not going to get any of these. They may.
So yeah, our email address is up there. If you've got any questions, then please come grab us this afternoon. We are both around, but we are also at the end of the line, or at the end of an email. Thank you.